All right, can y'all see the change in terms form online on the screen? Yes, no, maybe so.
Yes.
Great,
Yes.
thank you. All right, great. So you're in the midst of your contract. And this is for any of the agreements you have. This is a broker change agreement. It's called change in terms addendum. This would be for the contract. Actually, I'm a little bit further. Yeah, okay, this is not the form I was looking for. Anyway, we'll get to that in a second. All right. This form here is the escrow agreement between buyer, seller, and escrow agent. Where we have this in the contract with the Northern Virginia contract, Maryland has themselves a different addendum. So this is where the buyer is selecting it. It's not, make a point here, it's not part of the contract of sale, okay? But it is a form that's necessary to make sure the money is passed from the buyer to the title company and who they're choosing. So it's got the selection here, deposit defined, the receipt of deposit, who's handling it. Escrow agent shall within 7 days place the deposit in escrow agent's trust account. So, yeah, and that's the date. You got 7 days. That's the one thing about Maryland is keep in mind that Maryland will set dates for everybody and not make it negotiable. Okay. Yeah. 7 days. Whereas, and like even in the home inspection piece, we'll go over that a little bit more detail. It's set out how that's going to happen on the negotiation. You got 5 days, 5 days, 5 days, that kind of thing. Hey, Raekwon, could you close that door? Yeah. Thanks a lot.
Anthony, I
So,
have a question about the deposit for escrow.
right.
You have an inspection, like you have it like within the next 3 days, and you have a deposit. Some people will hold it like further than 3 days to make sure that the inspection is going smoothly. And so, if they rescind their contract on home inspection, do you still have to deposit the escrow in the account?
I mean, if you have the ability, if the contract is allowing you to get out before the deadline comes on the deposit, some would argue you should have deposited it. I'm like, you're within the confines of the contract. You're not breaking anything. You're not breaking any rules. You're not in breach. You're getting out because of home inspection. Okay, fine. Then you release the deposit. I would still have a release of deposit form, even though none has been deposited within the deadline, because you already decided to get out before that. Same type of thing with the 5 days on the disclosure form. Let's say you give yourself 4 days to get out, to have it deposited, but in 2 or 3 days they get out and it's not the 4th day. They haven't violated anything because the contract just became void. Contract said 4 days. I got out in 3 days. I didn't violate anything. I just didn't deposit it because it became void or terminated in Maryland. It became terminated before that deadline came up. So technically I would say, no, you're not violating anything.
Yeah.
Then you got the receipt of deposit, handling of deposit. And this is 7 business days. Okay. For deposit. If it's insufficient funds, if the deposit check is returned for insufficient funds or wires dishonored, escrow agents shall notify buyer and seller and their agents in writing within 5 business days from receipt of notice. So it takes 7 days and it gets bounces in 3 days. Now they have 5 days. What I don't like about this is we've got we've got 15 days we're into here. Now, I want to check something out. I'm sorry, guys. I need to double check this on the contract.
Is there a deadline for the seller to sign the release?
Right. So real quick, I want to amend what I just said real quick. The escrow agreement, it's not 7 days to get it paid. This is 7 days for the escrow company to get it deposited. The contract has how many days before you pay the EMD. So let's say the buyer says, I'll get it done in 5 days, and they get out in 4. Well, you haven't violated the contract by getting out and not having deposited if it's voided. But if you do, I'm going to have it deposited in 3 days, and you're sending a void in 5 days, then your money should have been deposited. But what I'm amending is that the payment terms of the EMD is negotiated on paragraph 8, and then the title company or escrow company has 7 days to get 7 business days to have it deposited. Okay.
Yeah. My question was, is there a deadline for the seller to deposit in case the contract is void?
I'm not sure I understand that. Can they do what? The seller do what?
You mean a buy?
Does the seller, is there a seller deadline to release the deposit, to sign the release deposit?
Oh, I see. Yeah. The contract says immediately if there's something, and we'll get to that on the termination. We'll get to that in a few minutes. But that does say if it's been deemed terminated and you've signed off, well, 2 things. There's a urgency for the seller to sign. This is usually where we see people dragging their feet, is the seller is upset and they don't want to release it, or they want to argue that there's no reason to release it. And so we'll talk more about that. But once that is signed, whoever's holding the check, once it's signed, they're supposed to turn around and get that check sent out to the buyer as soon as possible. Usually it says immediately. All right. Actually, it might be right here. This is, again, the escrow agreement. The real estate transaction settles in which the case the deposit shall be applied to the purchase price. We know that. Release. Escrow agent receives proper written instructions executed by both buyer and seller. Or if you can't get that and you have to go to court, the escrow agent files an action for interpleader and delivers the deposit to a court of competent jurisdiction. So if they can't get an agreement, what's happened in Maryland is they say, we don't want to hang on to these funds anymore. We're going to turn it over to the court.
Wait, so I thought that, so from my understanding, because I had a dispute over one, from my understanding, I thought it was that if there was no agreement, then the title company would hold the EMD for 30 days after the termination of contract. And then if no agreement was still reached within that 30-day period, then they would decide based on the contract who would get it. Is that?
They can do that.
Okay.
I'm just saying the 3 steps are, how do you release the EMD? 1, hey, we go to closing. It goes to the buyer's costs. Okay. Yeah. 2, we need a release of deposit agreement and a release of contract. When they get the proper instructions executed by both the buyer and seller, then they disperse it according to that agreement.
Right.
Yeah, I damaged you. It's 10,000. You take 5, I'll take 5. Okay. And remember, if that's a situation and the seller's getting 5,000, we agreed already in the agreement that we would get half of it or whatever we decided. You may have nothing. You may say, no, I'm going to give that back to the seller. But remember, there's still even more there to be considered when the deposit is being released. And then C, like what Raekwon said, there's a disagreement. No one can do anything. The title company's like, all right, you guys, I'm sending this to it. I'm filing an interpleader and I'm going to send the money to the court. So 7 talks about the disputes of it. And it's good for you guys to go through this parts of the paragraph and make sure you have an understanding of it so that me as the broker from the other side, and the title companies aren't trying to mop up a mess because no one understands what is supposed to be happening. Trust me, the title company attorneys, they understand what's supposed to be happening. So if you have a dispute, buyer and seller acknowledge that if the contract to sale obligates the parties to mediate deposit disputes, buyer and seller agree to abide by the terms of the mediation provision in the contract. That's what it says. Whether a buyer and seller are willing to now actually show up, that's always a challenge. If during mediation, buyer and seller execute a written agreement concerning the deposit, escrow agent agrees to accept and abide by the terms. Okay. Holding disputed funds. Escrow agent may, at its option, hold disputed funds until a release of deposit agreement is executed by buyer and seller. So they can hang on to it. It may be that the one you were working with said, hey, we'll do it for 30 days to you guys. And I get it. You don't want to, we're having an argument and in 3 days you go to court. You know, you might be able to fix that.
Yeah.
And they're giving it 30 days.
Gotcha.
Okay. And in the event of any litigation or dispute between buyer and seller concerning the release of the deposit, the escrow agent's sole responsibility may be met at escrow agent's option by paying the deposit to the court with such litigation as pending, or by paying the deposit into a court of proper jurisdiction by an action for interpleader. And I'm rushing through that, but that's the pecking order is, you guys agreed, I give it up to the buyer or the seller, and possibly agents get some of that for commission or compensation. 2, I hang on to it for a certain amount of time. If y'all can't figure it out, I send it to the court. Those are the 3 places it can go. And then the rest of this is like, and you're not going to hold me accountable for for doing that. That's what the rest of this paragraph says.
Gotcha.
All right. And then in the event buyer or seller fails to complete the real estate transaction in accordance with the terms and conditions of the contract, and they're unwaileable or unwilling to execute a release of deposit, buyer and seller hereby acknowledge and agree that escrow agent may distribute deposit in accordance with the following procedures. So we're going even further on this deposit, okay? But before they distribute it, they have to notify the buyer and seller that escrow agent intends to distribute it. Okay? The notice required under the section shall be in writing, state whether the deposit will be paid to buyer or seller, and disclose to buyer and seller that either party may prevent distribution by submitting a protest within 30 days from the date the notice was delivered or mailed by the escrow agent. If neither party submits a protest within 30 days from the date the notice was delivered or mailed by the escrow agent, the deposit will be distributed in accordance with the escrow agent's notice. So the escrow agent, that's the 30 days I think you're talking about. I've given you notice. I'm telling you how I'm going to do it, and they got to wait 30 days. If nothing comes back, they send it out. I've actually done that before where we had one. I had this crazy lady, man. She was violating the contract. It was clear she was violating the contract. This was years ago. And she started calling and arguing with me like, well, ma'am, you did this. Contract says X, Y, and Z, and they're going to go to court, and I can't send you anything until this is decided. Finally, she started calling the front desk time and time again. I want my money. I want my money. I want my money. And I said, okay, ma'am, now you're getting into harassment. I said, I don't know if you're hearing me or not, but if you call back again, I'm calling the police. I have your name. I have your phone number. I have your address. I will report you to the police for harassment. And the phone call stopped. Yeah, the weird things. Anyway. Oh, just screaming at us. It's like, okay. And then this is how it's got to be delivered. I'm not going to go deeper into that. The buyer and seller can protest at the distribution, how they can do that. If written protest is received by the escrow agent, how they can handle that. Okay. Right. This is all about the deposit. So attorney's fees and costs, you hope that doesn't happen, but if the loser usually pays the fees of the winner. And it just talks about that this is the entire agreement. Okay, what are we in? We're in escrow agreement. This is signed by the buyer and sellers, then sent over to the escrow agent. And usually all you have is this sent to them, and it's their job to get it signed, get it deposited, and then they send this notice to both the buyers and sellers to notify them that it has been deposited. Where's this delivered to?
Title, title attorney.
Title get attorney gets it, and then they have to send it back to who? To determine where are deliveries in the Maryland contract? I'm kind of jumping ship here on,
Email.
huh?
Email
Email to who?
to all parties.
It's to all parties, but honestly, it's to the agents. The
Well, yeah,
delivery is to the agents. This is not like Virginia. You're looking for that whole delivery notification. It's to the agents
Yeah.
in Maryland. I mean, they'll tag something on and send it to all parties, but if they deliver it to the buyer agent or the listing agent, it's been delivered. Any questions on this part? Okay. All right, so let's get into the contract.